Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Um, Real quick note on the sound. I installed a bunch of sound deadening material. So let me know if the high-pitched whistle from the computer is still audible on your phones. I think people tend to be hearing that on their phones, so please let me know the status of that. Now, the question. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user Autumn Ward 6210. And Autumn Ward asks us, Attorney Vincent, hello? I'm being represented by an employment attorney. That sounds positive. There were inaccuracies all throughout the demand letter to my now ex-employer. That does not sound positive. Did they have you approve that letter before it went out? Always a major faux pas. There's a lot of attorneys that want to rush the letter out, and it's like, whoa. You're setting out a narrative that you as the attorney did not live. Get it checked, right? And also just like the demand letter language, and make sure your client approves of it. And I'll be honest, like a lot of people are like, no, you should do this or do that. And it's like, no, you actually don't know what you're doing because you haven't done this before. But you're still the client, and we still have to be like, hey, this is good. And like, no, you should threaten their lives. Be spicy. It's like, yeah, that's not going to get you what you want, but you still got to have the conversation, right? I digress. Autumn, did they have you approve the narrative for that demand letter before it went out? Or did they just send out a letter? That's terrifying. Oh, Autumn goes on. To the point, I would call the statements in that letter outright lies. I told my attorneys via email everything that occurred. The demand letter didn't even get the names of my supervisors correct. Ooh. I'm concerned that this letter makes me look like a liar. Fair concern. Is this a strategy, or did they just not read the details of the events that occurred? I mean, I expect they probably didn't read. Or they got confused. Sometimes I've seen young associates get confused and like conflate two cases together. I've certainly seen that. There's miscommunications that happen between attorneys and clients. That's one of the reasons why you have your client review and approve for accuracy the demand letter, the filings. It's why you have them sign and verify your filings. There's a lot of reasons, right? Autumn Word goes on. I'll give one example. One male I worked with asked me inappropriate questions, and the demand letter stated that I told this person to stop with the inappropriate line of questioning, but that he continued and the following month propositioned me. I never told my attorneys that this person did that. I sent them an email with a list of the errors. One of the attorneys on my case gave me a call and said they don't want the employers to know all the cards they hold, so they just tell a third of what they know. I mean, that's not... Listen, I'm on board with the idea that you might only include the high points of a case in a demand letter. That I agree with. You wouldn't hit with everything. But that's got nothing to do with lies or just blanket inaccuracies in the letter. Those two things are not related. He said the errors aren't really a big deal because if this goes to court, it will be what is filed with the EEOC that matters, not the demand letter. I mean, the demand letter can easily end up in evidence. So, I don't know about that. I'm sure they are right about that. And I'm just worried that this demand letter will not be taken seriously. Yeah, that is the bigger concern, right? If your demand letter has a bunch of stuff in it that is verifiably not true, then the employer will say, oh, I suspect all of this is bullshit. And you almost can't really blame them, right? Like, if I come at an employer with a demand letter and the employer's like, I know for a fact that a lot of this is just inaccurate, so I suspect it's all inaccurate. That is like a rational cognitive leap, right? Like that makes sense. That conclusion tracks. And so then they think you are a liar when they might have otherwise done the right thing and believed you. Now, it is somewhat rare that employers just believe victims, in spite of the Me Too movement. But that being said, here, where they may be able to verify that multiple statements in your demand letter are false, I wouldn't really hold it against them if they then conclude that the rest of it must be false too. Because you know what lying liars do? They lie. And they could reasonably conclude that you, Autumn Ward, are a lying liar because your attorneys are either lying liars or dumb AF, to use the language of the youth. So, listen, I don't know what your deal is with these attorneys, but it sounds like they suck. And, like, if this was their first draft to you and you reviewed it and these changes were made and then it went out, that's fine. Mistakes happen. Miscommunications occur. Getting to know your attorney when you're first starting to work with them, the communication flow can be difficult. Things happen. That's normal. But there needs to be a review process. The idea that they would just take things you said, jot some stuff down in a letter, and send it out without you seeing it, that's like it's essentially like skipping a seatbelt. Right? I mean, it's actually worse than that because because you know there's going to be problems. Like there's you could just spend 20 minutes checking this letter for accuracy. 20 minutes. You live those events. You know what happened. All we need you to do is confirm that we got it right as attorneys, right? And that should, it's not that long a letter, right? Page and a half, 2, 3 pages max. I always laugh when people are like, I think we should do a 30-page demand letter. Oh, do ya? Okay. It's not going to happen, right? And there's definitely clients who are like, no, 30-page demand letter. Really? Let them have it. It's like, nobody's going to read that. That's not a thing. Stop. Shh. Right? But that being said, why would you skip the basics of just checking for accuracy? Which, again, takes at most 20 minutes of client time. It doesn't even really take attorney time, right? Attorney writes the letter. Attorney tells a pair, hey, can you have the client check this, make sure it's accurate? If it's not, get me notes so we can conform to accuracy, and then we'll have the client check it again. The client's good to go with this. Let's get it out today. Get it to me to sign. I want it to go out. Email, fax, hard copy, the whole package. So, Autumn, listen, I don't know what's going on there. If they have a good excuse for how that happened or why that step was skipped, fine, I guess. But if you and I were family at the dinner table, done. Zero chance you go forward with that firm. Gotta be honest with you. I'm stopping myself from using stronger language. I don't know what your attorney's arrangement was, but I assume they have at the very least, a fat percentage of your case. And the concept that they dashed off a half-assed demand letter that it sounds like could be worth tens of thousands, if not six figures, to just them, let alone what it could be worth to you, the client who they owe a duty of loyalty to. The concept that they skipped a 20-minute step to safeguard your claims and just to appear professional, to safeguard their reputation as an employment firm, right? That, to me, I don't care for it. I don't care for it one bit. Autumn, I wish you the best of luck. Everyone, tell me what you think down below. Should Autumn stay with this attorney? Weigh in. I'm very uncomfortable. I am very uncomfortable. Like, subscribe, comment down below. Share the channel so it can grow. Take care, everyone.